Good Saturday morning to everybody, and welcome to Legal Notes with Marianne Charron and Ned Barron from Charter Oak Law. I'm Gary Byron. Folks, we are taking a break.
We are.
From Medicaid this morning. We've really, I think we've elaborated on that quite extensively over the last month or so. I remember, was it a couple of weeks ago, I brought up Casey Kasem, who died in 2014, and his estate was not settled until 2019. And there are lessons to be learned from that case.
You had suggested Casey Kasem. I really didn't know much about the Casey Kasem saga, and it's crazy. You were right. I mean, it pulls up.
Yeah.
You know, first of all, he didn't have a will. His estate was worth $100 million. He didn't have a will. It's a second marriage for him. So there's all sorts of second marriage issues, isolation, elder abuse, allegations of financial exploitation, you know. So
3 children from a prior marriage who do not get along with
his second wife.
Stepmother, right, the second wife.
But he was married to her for quite some time.
Like 30 years.
Yeah, 34 years total. And, you know, so it's not as if she married him late in life, for example.
Sure.
But it was a long-term marriage that he had. But crazy, he didn't have a will. He did have healthcare power of attorney, and he had a living will. And what was fascinating is that he didn't name his wife Jean. He named his daughter. And the daughter, Carrie, is her name. He named her as the person who was going to make the healthcare decisions for him and make end-of-life decisions for him in the living will. So,
but that didn't occur.
Well, there was, of course, litigation, you know.
Dun, dun.
So Carrie had sued her because she wanted visitation.
So let's be specific. Sued Jean, the second wife.
Mm-hmm.
Yeah, okay.
So that she could have access to her father, visit her father, and understand the medical care that he was or was not receiving. And Jean, as the story goes, when Carrie went to court and won, and the court appointed Carrie as the conservator because of the existence of those documents. And so when Carrie went to her father's house to visit him,
Dad was gone.
Jean now, did she kidnap him? I don't know if she kidnapped him. You're married to him, but so the stories are that he was kidnapped, and they went. Jean took him to Vegas, and then ended up landing in Seattle, Washington.
What'd they do in Vegas?
Who knows? Because
were they seen or were they hiding out?
Well, as I understand, I think that they were hiding out.
Why would you go to Vegas to hide out, though? I guess because you blend in with everybody?
Because they heard that saying, whatever happens in Vegas stays in Vegas.
That was good.
Touche.
That was very good.
Look at this guy.
But, you know, the interesting thing is I remember reading in the news about this, and I remember that Casey Kasem was missing. Right.
Yes.
This is for a long time.
Oh, yeah.
Like this just wasn't, it didn't happen, you know, in a matter of days or weeks. This was for months. The family was looking for him, and they could not find him.
Yep. And he was not well at that point in time. So, mentally or physically. So he had Parkinson's, he had dementia, and Lewy body dementia.
Yeah, Lewy body dementia.
So he was nonverbal at this point. He was actually in a nursing home, and she took him out of the nursing home. And she started traveling with him. And they were eventually found in Washington. And of course, even though the daughter was the court-appointed conservator in California, that paper is only good in California.
Which is why the stepwife removed him from the state of California, because the court there did not have jurisdiction over him in another state.
Okay, but did Jean have authorization to go in and check him out from that facility in California?
Well, I mean, it's so interesting that you say that. I tried researching for this show. I did try to see if I could see what the copy of the document looked like, just to have an idea. And in California, maybe spouses have rights that are a little bit different.
You know,
I don't know what it is, but clearly she was able to take him out. The other thing I had read was that he was actually in that nursing home under an assumed name because she didn't want the public, to know where he was. Of course, the allegation is that she didn't want the children to know where he was. Jean's big complaint she had several complaints about the children, but she had claimed that Casey, because of children kept coming to him for money, that he stopped communicating with them in 2012, and that she was just honoring his wishes to not communicate. Eventually, he died in 2014. He died in Washington State. So he had bed sores and infections. He had sepsis. I mean, it was incredibly, incredibly sad.
I would imagine painful as well.
Sure. I want to just get back to the question you asked about, did she have the authority to remove him? At that point, our understanding is that the daughter had been appointed by the California court to be his conservator. And in Connecticut, if that had happened, then that spouse, Jean, would not have had the legal authority to remove him. Because if the daughter was the conservator and she had the authority
only the daughter would be able to.
Right, only the daughter would be able to do that. So in Connecticut, it's definitely there's no way that.
All right, so then in California, it must be okay. Otherwise, I can't imagine if that facility would be liable to anything that happened.
I mean, I suppose what she could have done is, knowing that the hearing was that day, maybe she took him before the judge actually issued his ruling. Oh. We don't know. I couldn't find out all those details.
But was Casey even there? Was he incapacitated, or would he even be physically in the courtroom?
No, he was not there. He was incapacitated at that point. So it was really tough. There were doctor's reports. I mean, it was just. I even had read that the daughter and family and friends held a protest. Only in California. Family friends protest in front of his house saying she needs to let us in to visit. She refuses to let us see our own father. And then, of course.
But doesn't the story get even more bizarre after that? Because didn't they go overseas? Didn't they go to Europe? I know he's buried somewhere in Sweden or something like that, right?
So there were battles over where he should be buried and who had the right to determine where his remains, where he would be buried. Okay. And so I do understand. I heard that too. I wasn't able to follow the trail as well in terms of what happened to his body, but his body, did travel, and she did take him when he was alive. Like I said, he died in 2014. He died in Seattle, and then the daughter sued Jean for wrongful death, claiming that she neglected her father, didn't provide him with the appropriate care. And then Jean countersued that the daughter was trying to actually kill her father, and just wanted the money from the estate. It was it's everything that Ned and I try not to have happen when families come to us, right? It's the exact opposite.
Right.
You want to be able to say, look, even if your decision was my kids get nothing, right?
Well, that's a decision.
Right.
It's a decision, and then we try to put in place all of those things so that you don't have 5 years worth of litigation. I mean, they fought over everything.
Do we know why Casey chose not to include his second wife, Jean, in his will and as a conservator?
Well, I don't know why he didn't do a will, right?
That's right. He didn't have a will. That's right.
So the articles that I was reading was because he didn't trust her, right? So he trusted the daughter. Who knows? Maybe he did checks and balances. Maybe he felt that,
Well, he may have already have started to be impaired by his disease that he had also, right? Because it was in 2007 when he signed the healthcare directive in the living will, and that's 7 years before he died. So that could have been going on. Something could have been going on already in him.
Could have.
So
that's true. I mean, certainly the Lewy body dementia. I mean, that kind of once it hits you, you go downhill.
So Robin Williams had, right? Well, Robin Williams had that as well.
So, but you can.
And and we know that Robin Williams suffered with depression.
Well. Yeah, right, all his life.
Right, all his life. But who knows what happened prior to that? I mean, we know also that he ended his life early too, right? I mean, he chose.
Yeah,
he did commit suicide. He chose not to go through the full process of the Lewy body dementia
because it's awful. It is awful. It's what my dad had.
Yeah.
So he had the exact same thing. And once that intersection of the physical pieces where you no longer have the motor control over your body, and then you have the dementia where your brain isn't even, it's really, you go downhill so fast and you lose the ability. 7 years, I don't know, 7 years in 2007, it certainly, he may have had capacity then, but who knows? Why did he not have a will? I mean, that's crazy. That boggles my mind.
At what age should somebody start considering a will? Is it when you get married, when you have children, or is it, if you're single, is it just an age? You just to really start documenting a lot of these things.
Mm-hmm.
Well, that's a really interesting question, and one that is, let's just say that money was no object for anybody to have a will, right? That let's just say the wills were done for free, that the government decided that, hey, it's part of all the stuff that's being given away now, having attorneys write wills, everyone gets a free will, okay? Assuming that. Then I would say...
part of the stimulus package.
Right. Hey, make attorneys great again, right?
Oh my God.
We're seeking to new depths here, folks. You're listening to Legal Notes with Marianne Charron and Ned Barron from Charter Oak Law Group. I'm Gary Byron. There's no depth that we will not try to reach on this.
Just trying a little bit of humor. Maybe it went a little far, but hey.
Go ahead.
Anyway,
and
so if that was the case, then I would say anyone who was of the legal age to be able to sign a will should have a will. So 18, right? That's the legal age where we all are considered to then have legal capacity. And the reason why is because, while an 18-year-old might not have assets at that time, and this is kind of a real far stretch, but let's just say for the sake of argument that 18-year-old got in a car accident.
Correct.
And it was somebody else's fault and they died. They have an estate now. And the person who caused the accident, caused the death, is now being sued, right? That 18-year-old has to have an estate in order to be able to sue for his wrongful death. And if a will is in place, then they will have named who's going to be the executor, and that executor would be the one who would retain the attorney, the personal injury attorney, to take that case to court, and then, assuming that they win, then now the asset, the payout is going to now have to be distributed.
But realistically, I don't know about you, but I don't know many 18-year-olds that have a will.
No.
So I agree.
No, there
were 20-years even.
Right. What we have seen, certainly I think COVID has shined a light on this, is that we have seen parents who have come to us who have been, I'll say, our client, right? Mm-hmm. And they have asked, maybe not for a will so much for their child, but for powers of attorney. Because what if something does happen? Let's say the kid survived the car accident, but was, who's going to make the healthcare decisions? Right. Who pays the kid just got a bill, got a job, and who's going to be able to handle those things? I have seen an increase in powers of attorney because don't forget, once you're 18, your parents don't get to pick up your prescription medication necessarily for you. Don't get to talk to the doctor for you. So I've seen that, not wills, but we've seen more powers of attorney.
And appointments to the healthcare representative, which is, so powers of attorney, generally when we use that phrase, it's for financial, but also that advanced medical directives regarding medical decision making and all that.
And you're right. I think that when people have a life event, a marriage, a child, have start to amass some sort of wealth, some assets that they feel that they worked hard enough for, that they want to make sure that the person or people they want to get it. That's usually when they come to us.
In this case of Gene Kasem, now that, I shouldn't say now, Casey's been dead now for several years.
Yep.
Would the daughter, the conservator, have any legal recourse against Gene Kasem now that the dust is settled?
Well,
Gene's not in hiding anymore.
No, they did settle.
Oh, they did?
And it was confidential settlement. Okay. So I'm assuming that as part of that settlement, they had to all sign releases.
And pay her off?
Well, everyone got paid off, so to speak, right? The money was finally distributed, and I suspect that there was a confidentiality clause. That's why no one knows what the settlement is. And I'd also be willing to bet, given the amount of litigation that existed in this with this family, that they had to sign a release and waiver so that there would be no further lawsuits against each other. In other words, that all claims were settled.
Right.
That they had or could have had. So,
how would you handle this differently?
Well,
who are we? No, really.
Well, or where are you? Are you in California or are you in Connecticut, right?
Right. Well, the question is, how would you handle this differently? You could ask that question of Gene Casey. You could ask that question of the daughter.
It depends on who you're representing.
You could ask that question of Casey Kasem. Right. How would you have handled this differently, right? If we were being asked to represent one of them, because they all had an interest and they all had different interests.
The fact that it's just so crazy to me that he would have had healthcare directives like powers of attorney and not had a will.
Yeah, I find that,
that's crazy.
Especially his age.
Well, he may have, and he could have destroyed it, right? He could have revoked it.
He could have revoked it. And I do understand that there was a trust that Jean was the trustee on. So there was this big fight. One of the battles in court was to take him off of life support. And so the daughter, Carrie, applied to court to take him off of life support. And because, claiming that he had no quality of life and it was just cruel to continue to have him on life support. Jean fought that. She wanted to keep him alive. And so there is some issues as to whether she was benefiting from his trust and she wanted to keep him alive, all of those type of things. We talked about trust in the last week's, where oftentimes a spouse will have a trust to allow someone to continue to support her. Clearly with $100 million, you would think there was plenty of money to go around and satisfy everybody. But it just boggles me that he had some of those documents and not others.
Well, also the interesting thing I think about the living will is that when we do estate plans for our clients, included in that package is a living will.
Yeah.
And what that living will allows that client to do is to determine, in the event that they are in a persistent vegetative state, meaning a permanent coma, or they have some other incurable medical condition and they're unconscious, and that without certain artificial life-saving procedures being given to them, that they would die in a relatively short period of time. And so you get to choose whether or not you want, for example, artificial respiration. So being on a respirator, artificial means of hydration and nutrition, like being on a feeding tube. Do you want those to be given to you? And if Casey Kasem's living will said, no, I don't want those.
It did. That's correct.
Right. So if it said that, and he met the standard of he was either in a persistent vegetative state or had an incurable medical condition, then that should have been honored, because that was what his wish that he made when he was able to make that wish.
And that's why the court agreed with the daughter and, allowed the life support to be withdrawn.
Folks, if this fascinates you, any of the topics that we discussed on this show, please check out the website charteroaklaw.com. Again, www.charteroaklaw.com. And the phone number that you need to write down to make yourself an appointment. 860-570-1229. Once again, 860-570-1229. 29. Offices located in Bloomfield, Danbury, and Norfolk. For Mary Ann Charron and Ned Barron, I am Gary Byron. Until next week, have a good one.